2 hearings, 1 question. When the system preserves a fraud challenge but sells the home. Hello, welcome to Silence Screams Loud Strength. I am your host, and this is Unmasking Justice. Today's episode is called 2 hearings, 1 question. And the question is, can justice remain meaningful when the court allows a challenge to continue but permits the subject matter of that challenge to be sold before the evidence is heard? This is not just a question about one home. This is a question about procedural fairness. This is a question about domestic abuse. This is a question about economic control, homelessness, participation rights, and whether the system truly understands what it means to be heard. Recently, 2 hearings exposed a deeper contradiction. At one hearing, questions were raised about why proceedings were being heard in a particular court at all. There were concerns about venue, transfer, prior findings, and whether the case had been moved away from the court where important matters had already been identified. At another hearing, the court accepted that allegations of fraud and material non-disclosure should not simply be dismissed. The court allowed time for evidence to be produced. That is important. It means the door was not closed. It means the application remained live. However, it means the court recognized that serious allegations required further examination. But then came the most important contradiction of them all. The court allowed the sale of the property to proceed. So, the legal challenge survived, but the home may not. This is the paradox at the heart of this episode. Because if the law says you may bring your evidence, but at the same time allows the asset at the center of that evidence to be sold, what does the remedy mean? What is left to protect? What does justice become when the subject matter disappears before the truth is heard? In law, interim injunctions exist for a reason. They are not final judgments. They do not decide the whole case. They exist to preserve the position until the court can properly determine the dispute. So the leading authority is American versus I think it's Acon ask whether there is a serious issue to be tried, whether damages are adequate, and where the balance of convenience lies. But when the asset is a home, damages are not always enough. A home is not just bricks and mortar. A home is memory. A home is safety. A home is identity. A home is the place where stability begins. And when someone has already been displaced, excluded, or made homeless through an operation of an order they are challenging, the court must be extremely careful not to use that displacement against them, because absence is not always choice. Sometimes absence is enforcement. Sometimes absence is trauma. Sometimes absence is the consequence of the very order now being challenged. So that matters because justice matters. It matters because the law cannot allow the consequence of a dispute act to become the jurisdiction for making that act permanent. That is secular reasoning, and in the context of domestic abuse, coercive control, economic abuse, and litigation imbalance, secular reasoning can become devastating. The Domestic Abuse Act 2021 recognizes economic abuse. Economic abuse is not abstract. It is not theoretical. It can look like losing access to property. It can look like being made financially unstable. It can look like being forced to keep paying for something you cannot live in. It can look like a legal process where one person has lawyers, resources, documents, and strategy, while the other is traumatized, homeless, and expected to perform litigation as though none of that matters. Well, it does. This is where participation becomes central to the whole process through Article 6. Article 6 is not just the right to sit in the courtroom. It is the right to a fair and effective hearing. There is a difference between being physically present and sitting in front of the judge in court and being able to actually physically participate. A person can be in court and still be shut down. A person can hear questions and not be able to process them in real time. A person can know something is wrong and still be unable to organize the evidence in the way the system demands. There's a distinction. That is why trauma-informed justice matters, not as a sympathy, as a procedural integrity. Because if a survivor cannot meaningfully participate, then the process may look fair on paper while failing in reality. And that is the heart of so many institutional failures in this modern court system. Recognition without implementation, rights without practical access, hearing without participation, orders without full disclosure. The court may say, bring your evidence, but the question becomes, did the system ever make the reality possible for the evidence to be brought before the damage was done? In this episode, it's not about attacking the courts. It's about asking whether the court process is equipped to handle the complexity of fraud allegations, company structures, domestic abuse, economic control, trauma, and self-representation at the same time or all at once. Because when these issues collide, ordinary procedure may not be enough. A litigant in person is often told, "You should have asked the questions. You should have placed a questionnaire. You should have filed the documents. You should have cross-examined. You should have obtained the transcripts. You should have done more." But the deeper question is, could they meaningfully participate? Could they understand the implications in real time? Could they respond under pressure? Could they navigate complex financial disclosure while in trauma? Could they match the resources of a specialist legal representation? Justice cannot simply ask whether an opportunity existed. It must ask whether that opportunity was real, and whether fraud or material non-disclosure is alleged. The issue becomes even sharper. Financial remedy proceedings depend on full and frank disclosure. If the court does not have the truth or true financial picture, then the order made may rest on an incomplete foundation. That is why Rule 9.9a matters. That is why material non-disclosure matters. That is why fraud allegations cannot simply be treated as an inconvenience or delay. They go to the heart of the integrity of the order itself. And if the order under challenge is the very order permitting the sale of the property, then preserving the property becomes central to preserving the effectiveness of that challenge. Otherwise, the law creates a hollow remedy. A right to argue after the loss, the right to prove the truth after the home is gone, the right to be heard after the consequence has become irreversible. That is not justice. It is something else. That is not justice in its full sense. That is procedure without protection. And this is why the question matters beyond one's case. Because across the justice system, survivors are often processed through structures that were not designed around coercive control. And not many understand coercive control. They are asked to prove the abuse. They are asked to evidence patterns. They are asked to respond to a well-funded opposition. They are asked to function while traumatized. That is not equality of arms. And when they struggle, the struggle itself is used against them. This is how procedural disadvantage becomes institutional harm. This is weaponization of the justice system. This is how homelessness becomes evidence of no need or non-need. This is how lack of participation becomes framed as choice. This is how missing documents become treated as failure, even when the person is fighting from a place of trauma, displacement, and survival. So today, I want to leave you with this. Justice is not meaningful because a court door remains technically open. Justice is meaningful when the remedy remains capable of working. If the challenge survives but the home does not, the system must ask itself whether it has preserved justice or merely preserved the appearance of it. Because a right that cannot protect anything is not enough. A hearing that comes too late is not enough. A remedy that arrives after irreversible harm is not enough. The law must do more than recognize vulnerability. It must exercise its powers, its natural powers. It must respond to it. It must protect participation. It must preserve the subject matter where necessary. That is justice. It must understand that in case involving homes, domestic abuse, coercive control, trauma, harm, damages are not always justice. Sometimes preservation is justice. Sometimes time is justice. Sometimes the simple act of stopping irreversible harm long enough for evidence to be heard is the difference between a legal process and a fair one. This has been Silence Screams Loud Strength, Unmasking Justice.